All right, good morning and welcome to CareerSource Palm Beach County's virtual coffee talk. My name, again, for those just joining us, is Eric, and I'm from CareerSource Palm Beach County. We are excited and glad that you can join us for the first of a multi-part series, and I'll talk more about that a little bit later this morning as far as the other events we have coming up. Just a few quick housekeeping points before I introduce our keynote speaker for this morning. As I mentioned, please make sure that your line is on mute, whether you're using your computer or your phone to connect. That way we'll avoid any possible feedback that might come through the line. If you have any questions, you can type them in the chat box, and we'll be breaking periodically with the presentation to share those questions that you have. If at any point, for some reason, we're unable to answer your question, we will certainly send those to our keynote speaker today, and we'll be following up with you shortly via email. I also posted in the chat box a link for closed captioning. So if you need to access that today, you can click on that link that I just posted. And again, we're excited to have you with us. And at this time, I'm going to just talk a little bit about our keynote presenter for today. We have with us, and grateful to have Bari L. Goldstein, Esquire. She's a partner at Ward, Damon, Posner, Peterson & Blau, PL, and they are a multidisciplined business law firm dedicated to protecting the legal interests of its clients by providing conflict resolution and effective strategies to help clients achieve their long-term objectives. Ms. Goldstein received her JD from the University of Miami School of Law in 1998. She received a BA in accounting with a double major in personnel management from Florida International University in 1994. She was admitted to the Florida Bar, and she's also admitted to the U.S. Supreme Court, the U.S. Court of Appeals for the 11th Circuit, and the U.S. District Courts for the Southern, Middle, and Northern Districts of Florida. Ms. Goldstein specializes in preventative labor and employment defense work, and represents and counsels private, not-for-profit, and public sector employees on various regulatory, administrative, and litigation issues that affect all aspects of the employment relationship. She advises employers on personnel issues, wage and hour matters and employee relations, conducts audits and investigations, drafts handbooks and human resource policies and procedures, and also presents workshops on various employment subjects. We're very grateful and pleased to have Ms. Goldstein with us today, talking about the Americans with Disabilities Act, compliance and related employment matters. And without further ado, I would like to turn things over to Bari L. Goldstein. Thank you.
Good morning, and thank you, Eric. Welcome to my office. I was going to use one of those fancy virtual backgrounds, but frankly, it gives me like helmet head. And then if I move the wrong way, it like takes off my body and it's just a head. So we're gonna go with the messy office this morning. As Eric said, my name is Bari Goldstein, and I'm a labor and employment attorney here in West Palm Beach. My focus for the last 20 years has been counseling employers on compliance issues regarding a myriad of labor and employment laws, which is perfect for today because one of those laws is certainly the Americans with Disabilities Act, and that's what we're going to be talking about today. A couple housekeeping matters. Welcome to 2020. Now we do these virtual webinars, which is great because it allows a whole lot more access to so many different people. You also don't see my hands like you always do when I'm giving in-person presentations. That being said, it does eliminate the engagement between myself and the participants. So we do ask that you feel free to ask any questions that come up, and we may intermittently throughout the presentation go ahead and pose some of those questions, and I will certainly try to answer them. Certainly when you are going to ask a question, make sure that you are general and generic. Don't refer to specific employees, don't refer to your company. Let's keep this neutral. You can use the what if scenarios if you prefer. Certainly, we hope to get to all the questions today, and I hope to be able to answer all your questions. But if we can't, we will go ahead and send them out to the participants thereafter. So a couple other things, because this is a virtual webinar, I did add more words to each of the slides than I normally would do, because I was trying to anticipate questions that you guys might have and also allow you to see the words on the screen, because you can't raise your hand and say, can you repeat that? So with that being said, our agenda for today is going to be talking about the Americans with Disabilities Act, in particular, the act itself, reasonable accommodations, the interactive dialogue, as well as I threw in some COVID-related issues, because I know that is certainly on everyone's mind. And then I do have some case studies at the end if we have time to get to them. So I get my mouse working. So let's talk about the Americans with Disabilities Act. The Americans with Disabilities Act is a federal law that prohibits discrimination on the basis in employment. And it's a federal law, meaning that it's the same throughout the entire United States. There are not, Florida itself does not have a state ADA type of law. So certainly this law applies to everyone across the United States equally. The ADA requires employers to provide a reasonable accommodation for qualified employees with a disability, and we're going to dig deep into what exactly that means. The other thing it protects is applicants and employees from retaliation. We're not going to touch too much on retaliation, but just know that if an employee comes to you and does request some kind of accommodation or some kind of modification because of a disability, and you either don't do that or treat them differently thereafter, there are retaliation implications. It also could be if someone comes to you and you intimidate, and there's intimidation that would preclude them from moving forward with asking for an accommodation. That could also be some kind of retaliation. So, coverage. I think it's important to know a lot of employers don't realize this, that if you are a super small company, you actually may not be covered by the ADA or any of the like kind discrimination laws that are out there. So for purposes of the ADA, it is actually applicable to only organizations with 15 or more employees. So if you're a company out there with 3 or 4 employees, what does that mean? It means that you're not covered by the law. Now, I'm not saying go out and say I'm going to discriminate against everyone because of their race or sex or their disability because I'm too small to care. That's not the message to be heard here today. Rather, it's that there is a defense that should you be unable to comply, it wouldn't be you'd have to get into the factual analysis of why or why not you did what you did. The reality is if you can show that you don't have the requisite 15 employees, that's an immediate defense to coverage. So you're not even covered by the law. So therefore, there can't be a lawsuit brought. Now, just a point that I need to make, a lot of companies have a myriad of different companies, and some may be very aligned with each other, i.e. using the same HR, the same payroll, et cetera, et cetera. And if you're in instances like that and you say, well, I only have these 9 companies and they all have only 4 employees, so I'm good, that may not be the case. If you push down deeper, you may be able to show that in fact, these are companies one and the same with common ownership and control, and therefore you could still be covered. So those are just things to keep in mind. So how does the ADA impact those covered entities, if you will, the ones with over 15 employees? Well, it requires anti-discrimination, harassment policies and procedures. Hopefully you already have those in place. I'm going to include later on some language with respect to ADA compliance in a policy. It also requires employers to provide reasonable accommodations to qualified employees with disabilities. Again, we're going to dig deeper into that in just a little bit. Requires employers to engage in interactive discussions with employees regarding accommodations. Again, we're going to talk about that. And again, it prohibits retaliation. So let's talk about the ADA and the ADAAA. I'm going to go into these in detail. First, the ADA. It was enacted in 1990. It protects the disabled in public and social settings, including employment. It prohibits discrimination. It also requires reasonable accommodation absent an undue hardship. And I will talk about undue hardships in just a little bit. So what does the ADA protect? A qualified disabled person. Who is that? A person who has a disability and who is qualified for the job. Now, keep in mind that this is applicable to both employees and applicants, and we're going to talk about that today as well. So this is who is going to be covered. So if you don't have a disability, you're not covered by this particular law, or if you're not qualified for the job, this may also not be applicable to you. So in other words, the ADA prohibits discrimination against a qualified individual with a disability. So who is a qualified individual? So I just lost my screen. So hold on a second. Okay. So a qualified individual with disability is someone that satisfies the job-related qualifications, skill, experience, education, licenses, etc. Can you guys still see my screen, Eric? Because I lost it. Eric?
Yeah, I see the screen that says what is a qualified, or who is a qualified individual with a disability.
Perfect. Okay, I don't see it on mine anymore. Okay, back to this. So a qualified individual with disability is someone who satisfies the job-related qualifications. So obviously, if someone's going to come in and ask for a disability, if they're not even qualified for the job without any kind of reasonable accommodation, they're not going to be covered by this law. They must be able to perform those essential functions of the job with or without a reasonable accommodation. And again, we will talk about that shortly. So what is a disability under the ADA? It's one of three things. It's either a physical or mental impairment that substantially limits one or more major life activities. It's a record of such an impairment, or it's regarded as having such an impairment. I want to talk about regarded as first, because I think that that can sometimes get employers into trouble. So for example, if you have someone who may have undergone some sort of cancer treatment years ago while they were an employee, they recovered thankfully and they're all good now, and they're up for a promotion, and you say, well, wait a second, that, you know, Joe had cancer 5 years ago. What if it comes back and he can't do the job? Let's not give him this job. That would be regarded as having such an impairment, because the person at that point in time is not unable to do the job, is not even really considered someone with a disability at that point in time. And yet you are putting the thought process, you're including that in the thought process. So that could be a potential ADA violation because you were regarding him as having a disability. So let's fast forward now to about 12 years ago. The ADA was amended, and it's called the ADA Amendments Act, which is the ADAAA. It was enacted in 2008, effective in 2009. It clarifies the disability definition just a bit. It broadens the number, and this is the key part with respect to the ADAAA. The ADAAA significantly broadened the coverage of the ADA, and it turned the focus into whether a qualified individual has been discriminated against on the basis of his or her disability, rather than whether the individual is a person with a disability. And what does that mean? It means in most cases, when you get a doctor's note from an employee saying, I have this, that, or the other thing wrong, and I need this reasonable accommodation, you don't necessarily focus on, is that person actually disabled? You more so focus on, is this a reasonable accommodation we can do that would allow them to do the job? So again, the ADAAA is intended to apply a less demanding standard than that applied by the courts, and therefore it covers a much broader range of individuals. It provides that the definition of disability shall be construed in favor of broad coverage. So, and you can just see back when this was first initiated, the 1999 congressional estimate estimated about 43 million Americans have disabilities that would fall under the ADA. However, when the ADAAA came to pass, it was estimated that 38.4 million more workers would fall under it. So you can just imagine the coverage that now this has been brought in to include, and it really has heavily increased the coverage of the ADA and therefore the coverage of individual employees. The ADAAA, excuse me, retains the same definition of physical or mental impairment that substantially limits a major life activity, a record of such an impairment, or again, being regarded as having such an impairment. Again, that being regarded as can become pretty messy for employers if they're not careful, that they are sure they're making decisions based upon legitimate non-discriminatory reasons and not because of someone being regarded as having some kind of disability. So let's quickly touch on what are these major life activities. So what are the major life activities under the ADAAA? And here's a listing, and this is not meant to be all-inclusive. And you'll see that this is quite a broad list. Speaking, breathing, reading, thinking, communicating, working, sitting, reaching, standing, eating, hearing. I mean, it covers basically everything. So it really does broaden the coverage of someone who is potentially disabled. Again, the EEOC emphasizes this is not a non-exhausted list. So just because you have someone who comes in and has a different kind of major life activity that they say they can't do, that does not necessarily mean that it's not in this list. That doesn't mean that they're not in fact disabled. So, and here's an interesting slide. Can impairments that are episodic or in remission be considered disabilities? And again, this is a change from the ADA because it clearly is yes. So epilepsy, hypertension, multiple sclerosis, asthma, diabetes, major depression, bipolar disorder, schizophrenia, and cancer. Again, these are things that may not actually be impacting the employee right now. However, they are still considered a disabled individual. So do the regulations require that an impairment lasts a particular length of time? Again, this is something that came to pass in recent years. So a short-term impairment may actually be a disability. This was actually not really addressed in the ADA, but it is very addressed in the ADAAA. So a temporary disability of some kind would in fact be covered and would require the employer to engage in interactive dialogue and potentially afford that employee a reasonable accommodation. Hey, Eric, do we have any questions thus far while I transition to reasonable accommodations? No?
So just a quick question, talking about with the ADA and the ADAAA. You mentioned, if you could just elaborate a little bit more on the point with if a company has fewer than 15 employees, let's say an individual came in and asked for an accommodation and the employer said, we're not able to provide that, how would things progress from that point if it was covered under fewer than 15 employees?
So, okay, so if there's under 15 employees, excuse me, then it really kind of stops there. What would happen, let me talk on both things. For over 15 and under 15, really the next step for any employee would be to go to the Equal Employment Opportunity Commission, file some sort of claim. Again, if in fact there's a charge filed with the EEOC against an employer that potentially has less than 15 employees, the response would be, we're not covered. Here's our tax documents to prove we have less than 15 employees, and the charge ends there. If it's a company with greater than 15 employees, certainly they're able to do a lot more with respect to reasonable accommodations because they are bigger, they can probably afford more kinds of accommodations. And a charge would ultimately have to be investigated and the employer would be required to respond. But again, if you have under 15 employees, the answer would stop there. That being said, let me just repeat, I certainly do not want employers with less than 15 employees to say, we're not covered, we don't need to engage in this process. I would still implore you to engage in what we'll talk about shortly, the interactive process, and see if there is something that can be done. Some reasonable accommodations really don't require a lot of financial money or other kinds of changes. In fact, it may just be, we need to start later because I have medical issues in the morning, maybe difficulty getting up. And certainly most employers would be able to accommodate that kind of request. So let's go into then what is an employer's duty of reasonable accommodation. So the main purpose for all of this is to assist an employee in performing the essential functions of the job. Let me talk briefly about the essential functions of a job. The essential functions of a job should be clearly delineated in preferably a job description. So this is a perfect opportunity. If you don't have good job descriptions right now, this is a very good reason to go back and try to get those pen to paper and get those documented, because this will help you in a whole variety of situations. It will help you not only with ADA, but also with FMLA issues, because you need to determine what the employee is or is not able to do upon their return to work. It will also help you just in performance issues to make sure that you have down the essential functions that you want this person responsible for. But most particularly with respect to ADA, it is important because it will focus on what the employee is able or not able to do with respect to essential functions. So according to the DOL, a reasonable accommodation is an adjustment or modification to a job or the workplace or the usual manner or circumstance of performing the job that allows an applicant or employee with a disability to successfully apply for the job, perform the duties of the job, or enjoy the benefits and privileges of the job. Let's stay on this slide for a moment and really dig deep into it. So an adjustment or modification to a job, that's easy. Basically, it would be to take away or to add certain job functions, possibly change their schedule, something to that in that regard. To the workplace or the usual manner or circumstances of performing the job. So potentially it could be they need additional disability parking, or perhaps they need a new chair or something like that, something that will allow them to do their job. And again, it applies to applicants and employees, but they must have a disability. You know, most times you tell HR people, don't ask employees about their medical issues. In this instance, you're going to have to ask, and it's okay to ask. And it's okay to get more information if necessary, because you really need to determine, first of all, that they are disabled, check. Then, is this reasonable accommodation they're requesting tied to that disability, and will it actually help them do their job? So if they come in and just say, I have headaches, that's not really going to help. If they come in and say, I have a neurological issue with seizures and an epileptic, that is going to be a much different discussion. So again, we need to talk in terms of helping employees and applicants either do their job or apply for their job. And that's the next part of this, which is the reasonable accommodation could be to successfully apply for the job, perform the duties of the job, or enjoy the benefits and privileges of employment. We're going to talk in just a little bit about applications and applying for jobs. Certainly performing the duties of the job, that's really the main focus of reasonable accommodations generally. So according to the DOL, when it comes to reasonable accommodations, how do you request a reasonable accommodation? You just ask. It's that simple. Now, interestingly, the just asking, there has to be some kind of tie-in to reasonable accommodation. However, there is certainly no requirement that you have to say, I need this reasonable accommodation. For example, it could be, as I mentioned earlier, I need to come in an hour later because I have a medical issue in the morning. It could be, hey, my wheelchair doesn't fit under my desk. That right there, that's a reasonable accommodation. They need a different desk. They have not said, I need a reasonable accommodation of fixing my desk, but the request has been made. It could also be, I need 6 weeks of leave for cancer treatment. That would be an ADA issue. And the leave would be granted under the ADA. And again, they don't have to say, I need this reasonable accommodation. It's enough to say that. Now, let me make another statement with respect, going back to the leave request. Keep in mind also, for those employers that are over 50 employees, they are required to give family and medical leave. So keep in mind when someone exhausts their family and medical leave, but say, for example, they still need additional month, 2 weeks, 2 months of leave. Now we're going to turn that FMLA issue into an ADA reasonable accommodation issue. So now they've exhausted all their family and medical leave. However, they're asking for 2 weeks of leave. Under the ADA, that would be the employer would be required to provide that as a reasonable accommodation. But again, keep in mind, they don't have to use the words reasonable accommodation to make such a request. That being said, if they simply come and say, my chair is uncomfortable, that's not a reasonable accommodation. If they go further saying, I have severe back issues, here's my doctor's note suggesting it, I need a different chair, that's a completely different discussion. Again, how to request it, just ask, no special process, no special words. I want to just pinpoint on this, no special process. Certainly, it is best if the employee goes to HR or whomever is in charge of those types of issues, because you guys know how to deal with it. A regular manager may not know how to handle it. However, what the employer must do is train its employees. Quickly transitioning over to like a Title VII issue, when you're talking about harassment complaints, you should have a harassment policy that delineates who should get harassment complaints. However, if any manager received a complaint of harassment, it is now imputed to the entire organization, and that manager needs to know what to do. Same thing here. If an employee goes to their manager and says, my desk isn't wide enough for my wheelchair, they've now given a manager a reasonable accommodation request, and that manager needs to, they don't need to know how to deal with it, but they need to know, hey, we need to go to HR because they need to deal with this. So make sure that your managers are trained on ensuring that they are able to get these reasonable accommodations across. Finally, the request doesn't have to be in writing. That being said, I encourage all employers to always get these things in writing. It helps you, it helps the employee, and we're going to go into this a little bit more, but certainly it is best for you to get any kind of request in writing from the doctor. And again, we'll talk about this in a little bit, but a quick side note, I handled a matter last year, I guess, where there was an employee who was requesting a reasonable accommodation. They were a bus driver, and they were saying that they could not drive. The doctor's note said they needed air conditioning in their bus because of some medical condition that I don't recall. The employer engaged in interactive dialogue and discussed the fact that they could not afford to put air conditioning in all their buses. The buses were not assigned, so there was no way to know that, in fact, this particular employee would get any particular bus at any particular time. So they engaged in interactive dialogue and spoke to the employee and determined that, hey, a fan would work, as well as cold liquids. So that was agreed upon. They then put an email back to the employee saying, here's what we discussed. Again, unfortunately, we can't do the air conditioner, but you agreed that a fan would be okay and cold beverages in a cooler would be okay. Fast forward, and that employee files a charge, and now all of a sudden they're saying you didn't accommodate our request for an air conditioner. And we have emails back and forth with the employee. The employee never said, no, that's not what I agreed to. Rather, there's clear documentation that shows that the employer engaged in the required dialogue and worked to assist that employee. Of course, they didn't give the preferred accommodation, which we'll talk about in a minute, but they came up with something else. So again, make sure that you're documenting these discussions with employees. Let's talk about how the ADA applies to applicants in the application process and removing barriers to applying for jobs. So the reality is that as employers, you need to make sure that your applicant process is disability friendly. What does that mean? That would mean if you allow applications online, there should be language on the internet when they're applying that says, if you require assistance with this application, please contact so-and-so. It could be if employees must come into the office to apply, that there is an instruction that receptionist gives that says, you have to fill this out, or if you need assistance, let me know, and someone may have to sit with them to use the computer or read them the application or whatever. You need to think these things through and make sure that, in fact, you have it on the internet and you have your receptionist trained that when applicants do come in, that you have some kind of process to allow applicants to also benefit from reasonable accommodations in order to allow them to apply for a job. That being said, include information on your website and in all your forms. In addition to being on your website, you should probably also have it directly on your application that says, if you need assistance with completing this application, please contact HR, phone number, email, however it is, to ensure that you are giving all applicants a fair shot at trying to apply for this job. Moving on to the interactive process. That was a reasonable accommodation. Now let's engage in interactive process, which is probably one of the most important aspects of this. Eric, do we have any questions from the reasonable accommodation section, or should I move on?
Actually, I have 2 questions in the queue.
Okay.
I'll read them to you and I'll have them ready to go. So the first question was, with the ADA, going back just a few slides, if there's under 15 employees, would that count Title I and or Title III? And then the other question we have is, must an employee request an accommodation if the employer knows about it, but the employee doesn't come directly to them?
Okay, so the first one, Title III would apply regardless of how many employees you have. And Title III, for those people that don't know, is the ADA provisions that talk about making sure your office is accessible to the public, making sure you have the proper amount of parking spots, making sure you have proper entrance, making sure your bathrooms are accessible. And that's a whole nother area of law that lots of employers are, frankly, right now there are individuals out there that simply go to, in particular, restaurants or shops just to see whether or not they're compliant with the ADA, and then they do bring lawsuits based upon the fact that they're not compliant. The second question, remind me the second question again, Eric, I'm sorry.
So the way I interpret the second question is, let's say there's an employee on staff that is in need of a reasonable accommodation, but they don't go to their employer. Is there anything the employee should or could do? Like, can they approach the employee, or would that be a moot point since no request has been made?
Perfect. Okay, thank you, Eric. Actually, I'm going to talk about that in this section. And the reality is that the employer is not required to go to the employee. The employee is supposed to initiate the discussion. However, that being said, if, like going back to what I said earlier, even if they haven't used the magic words of reasonable accommodation, if statements have been made that certainly appear to present the fact that there is a reasonable accommodation need, I would urge employers to pull that employee aside to discuss it with them. You don't have to be mind readers. You don't have to speculate. But if you have enough information to know that there is some sort of issue, then I would urge you to go ahead and talk to them about it. But as soon as you'll see in just a little bit, it is the employee's responsibility to engage or to initiate the discussion. So the interactive process. Here we go. Employee applicant must usually initiate the process. That is how it should be. Employers cannot be burdened with having to know what every employee needs. That being said, it is not the employee's sole burden. The employer must also share in that burden as soon as they have information that would make it seem to them that there is in fact an issue that needs to be addressed. So according to the EEOC, under both the ADA and the ADAAA, employers are required to engage in a dialogue with employee requesting a reasonable accommodation. That's simple. An employee comes to you, you need to talk to them. You shouldn't dismiss them. You certainly shouldn't intimidate them. As we spoke before, that would lead to some kind of claim of retaliation potentially. But you need to involve in the interactive dialogue. However, it is usually prompted by a request from an individual. So again, employers are not mind readers, and certainly they have more than one employee to worry about, so they can't always know that in fact there are lots of issues going on. That being said, they do need to have their ear to the floor to see if there are discussions being had that they need to become involved with, and certainly they need to do that. So the ADA does not require employers to speculate about the accommodation needs of an employee or an applicant. The EEOC indicates that, quote, generally, it is the responsibility of the employee to inform the employer that an accommodation is needed. Now, it's that magic word right there, generally, that causes you to pause for a moment, because it doesn't mean it's all the time. Generally, it is the employee that initiates the discussion, and it is their responsibility to come forward. However, again, be careful, because what we talked about before, there's no magic words, there's no magic process. And in fact, while HR may not have the information that there's an accommodation needed, perhaps that employee spoke to their manager. So in fact, that knowledge has been imputed to the entire organization. So maybe the first step would be, if HR is hearing things, but they haven't yet seen the employee and the employee hasn't come to request any kind of accommodation, maybe this would be the perfect opportunity for the HR to go to the manager to say, hey, is there anything we need to know about Sally? And does she have, and is there an issue with her hearing or her seeing or something in that regard? And see if perhaps the manager does have information already. So as I said before, I am providing you with some simple policy language. I review a lot of handbooks, and sometimes I see pages and pages of an EEO policy, and I generally cross that out. I usually include this in addition to your regular EEO policy. And what I have here is, consistent with its commitment to equal employment, the company will work to accommodate disabled employees in keeping with applicable law. If an employee believes he needs an accommodation because of a disability, he should make a request to whomever, and the company will engage in interactive dialogue with the employee to determine the best course of action. A couple things about my sample policy language, and certainly you're welcome to steal it or not. It does not focus on applicants, because keep in mind, applicants don't get the handbook. So applicants, their necessity for language like this would again be on your internet or on your actual application. For employees, however, it is important for us to show that there is a process in place. Now, again, just like in harassment policies, if in fact the employee does not follow this direct policy, that does not mean they lose out on the opportunity to engage in the interactive dialogue and get any kind of reasonable accommodation. No, that's not the case at all. This is just the suggested procedure, and your managers need to know this procedure. So again, if they hear from an employee, they know, hey, in keeping with our handbook policy, we need to go to HR. Let me take you, or let me send you there, or let me call HR and have them come and see you. But again, this lays out that it's the employee's responsibility to go and to bring that language forward. So it doesn't have any kind of, in my policy, it doesn't say, employer's going to come and see you. That's not the case. The case is that we're consistent with our commitment to equal employment, and we're going to comply with the law, and that requires you to come to us and us to engage in the dialogue to determine the best course of action. It doesn't say we're going to give you exactly what you need or what you want. It says that we're going to determine the best course of action, which may be a modification of what the employee is asking for, and we'll talk about that in a second. Again, importantly, while the employee initially brings this discussion, the employer needs to participate in the discussion and engage that employee to get to a resolution that everyone can deal with. Oops, I think I went backwards. Here we go. Keep in mind, again, let's go back to what I said before about job descriptions. Job descriptions are pivotal. They're pivotal for a couple reasons. First, job descriptions show employees what their expectations are for the job they're doing. They're even more pivotal when it comes to this kind of interactive dialogue with reasonable accommodations for two reasons. First, it allows you to sit down with the employee to say, here's your essential functions. What can you and can you not do? More so, it is helpful to have the employee take their actual job description to their doctor to say, hey, here's my job description. Based upon the disability I have, is there anything I can't do? Or what can I do? And I've even gone so far in some cases when it gets further on in the discussion, there's an issue, I would craft a small email to attach to the job description that says, dear Dr. So-and-so, so-and-so is an employee here in the position of boom. Here's her job description. And for example, if that employee maybe it's a driver, or that employee is responsible for operating heavy equipment or for lifting certain amounts, I may specifically outline that, take it out of the job description and highlight it in a little cover letter. And then have the doctor sign off on, is the employee actually able to do this job with or without a reasonable accommodation? Or are there certain things this employee cannot do? And that will really help you focus on what those pivotal essential jobs functions are for the employee to make sure that they can do them. It also helps you show the employee that maybe they are not able to do this job at all, or maybe the reasonable accommodation or the disability they have doesn't impact them doing their job. Let me, as a side note, mention essential functions. For example, if you have someone with a disability like epilepsy, they are precluded from driving, say, a commercial driver's truck. So if you have any employees with CDL licenses, which are commercial driver's licenses, having epilepsy is a prohibitive disability, unfortunately. So if someone has epilepsy, they just cannot drive a commercial vehicle. And in fact, if you have someone with a CDL license, in addition to having a regular doctor's note, you would also need DOT, a Department of Transportation doctor, to do an examination. And something like epilepsy could eliminate them from being able to do their job. And if, in fact, I just saw one yesterday, and a doctor's note came through and it said, so-and-so was seen for medical issues involving neurological issues and having seizures. Now, that doesn't say epilepsy, but it certainly sounds like epilepsy. And that would be one of those instances where, as I mentioned before, sometimes you need to dig a little deeper and you need to actually ask for more medical information. Because in this instance, having one seizure may not be disqualifying. I'm not sure, I'm not a doctor, so I can't tell you, but having epilepsy clearly is disqualifying based upon the federal regulations. But again, you don't have to eliminate any essential functions. So if this employee is a driver for you and they cannot drive, they might not be able to do that job at all. You might have another job for them, you might not, but you certainly don't have to completely change the job. That's not a requirement to eliminate all the essential functions. Keep in mind, again, going to the job description, what are the essential functions versus what are the marginal functions? So keep in mind that if employees cannot do maybe a marginal function on their job description, that's not going to dictate that they can't do the actual job. Employers should require that employees obtain written documentation from their doctor regarding the need for an accommodation. If you come away with nothing else today, I implore you that when you're having discussions with employees, and certainly I urge you to have these interactive discussions, even if you don't have a doctor's note in hand, it's certainly best to do that initially. But even if you don't, have the discussion with the employee, listen what they have to say, engage in the interactive dialogue to determine, based upon what the employee is telling you, whether or not they can actually do the job with or without a reasonable accommodation, and what would that potential reasonable accommodation be. However, all that being said, at the end of the meeting, this is great. Thanks so much for talking to us. Here's what we've decided. However, before we can move forward, I need a written doctor's note. Unfortunately, there have been way too many instances where employees, I'm not going to say that they lie, because maybe they just hear what they want to hear, or maybe they think that they can do things that maybe they can't, or maybe they think they can do things that maybe they can, and they're saying they can't. So it is imperative that you get from the doctor what in fact the employee can or can't do. This will save you in more ways than one. First of all, you need to have that documentation in your personnel file. You need to have that documentation when you call me or your labor and employment attorney of choice and they say, well, what does the doctor say? Because you can't do anything without knowing what the doctor's saying. If the employee comes in and says, I cannot do this part of my job anymore, okay, I need a doctor's note, and then we can talk, or what exactly are you saying, and get me a doctor's note. You need to make sure that you have that documentation before moving forward, because again, you cannot take the employee's word for it. Certainly don't tell them I think you're lying. Don't tell them I don't think you're telling me the truth, but tell them, okay, I understand everything and we had a really good conversation and here's where I think we're going to go. However, before we can take that next step, I need it from the doctor. And again, I mean, even more so, it's important if you have an employee in some kind of safety sensitive job and they're saying, yes, I'm released to full duty. Well, no, we need it from the doctor. Same instance, if you have any employee ever returning from any kind of leave, before you put that person back to work, you need to get a doctor's note, because the employee, they may just want to come back to work and may be ignoring what the doctor said, who said maybe he or she needs another 2 weeks of leave. And they say, no, I'm good enough. I'm going to go back to work. Well, certainly you don't want to put that person back to work and have them get even more sick or more injured because they were not able to be released to return to work. Same situation when you're talking with the ADA. You need to make sure that the employee is actually able to do the job, and or if they're not able to do the job, what will it take to have them be able to do the job? Critically, employer's obligation is to provide an effective accommodation, not necessarily the preferred accommodation. Recently, I had a scenario with a client who the employee came in and said, I have serious allergies and my cubicle right now is under this one vent. I need it moved. Okay, fine. Here's Susie's cubicle, Joe's cubicle, Mike's cubicle. Which of these works? And we'd be happy to transfer you. Nope, I want that cubicle over there. Unfortunately or fortunately, the employer does not have to abide by the exact accommodation requested, especially if they're asking for this cubicle and this one is available, unless they could show that in fact that one is the same issue with the vent, or this in this particular situation, the employee was just saying, that one's too loud and that one has too much traffic and that one is too far from the restroom. Those are all not going to work. The employer's obligation is to engage in interactive dialogue and to certainly talk about what kind of reasonable accommodations would work. I want to transition second to mental illnesses when you're talking about reasonable accommodations. Mental illnesses are probably the most difficult to work with employers on, or employees, I should say, because they're usually you don't see that someone has a disability. If someone was out for cancer treatment or has a prosthetic leg or has hearing issues, those things you can see. With the mental illness, it's not easy to see. So when the employee comes in, you really have to work with that employee to determine what they can and cannot do and how you can work with them to allow them to get their job done. And it may take a little extra work than someone who is a much more visible kind of disability. So possible reasonable accommodations: job restructuring, making facilities accessible or usable, modified or part-time schedules, transfer to a vacant position, acquiring or modifying equipment, or giving any kind of leave. Again, these are all possible reasonable accommodations. This is a very fact-intensive type of discussion that you have with your employees. It's not one size fits all in any way, shape, or form. You're going to have to talk to that employee and determine whether or not there is a reasonable accommodation that you can offer. Keep in mind, indefinite leave is never a reasonable accommodation. What do I mean by that? If someone comes in and says, well, I need 2 years of leave and then I'll come back. That's indefinite leave. That's actually not indefinite, but it's so far in advance that is not a reasonable accommodation. That is a discussion that you must have with the employee to determine whether or not they can return sooner, or in some instances, you may not be able to give the accommodation they're requesting. If in fact they are having treatment and there is no way to know how long they're going to be out, I encourage you to initially have discussions with the employee to have updates given every 2 weeks, every 4 weeks, every 30 days. If they say, we imagine it's going to be 4 weeks, but we just don't know, well, that's not necessarily indefinite leave. That would be, let's check back in 4 weeks and see where we are. Now, it does seem in recent days that employees are becoming much more savvy with respect to getting extended leave. And what do I mean by that? They initially say, I need 30 days. 30 days comes and goes. They say, I need another 30 days. 30 days comes and goes. There is case law out there that says that if the employee cannot now or at any time in the future return to work, then that could be deemed to be indefinite leave. I caution you to be careful in those instances and certainly engage with your counsel to make sure that you have a leg to stand on with respect to saying this is indefinite leave and we don't have to accommodate it. So what is not considered a reasonable accommodation? Elimination of essential job functions. Again, any kind of, if the employee is a driver, you don't have to eliminate the driving function entirely. Lower production standards, providing personal items. You're not responsible for giving prosthetic limbs, wheelchairs, eyeglasses, or hearing aids. And undue hardship. So let's talk about that one because that generally is the issue that comes up most. So what is considered an undue hardship? Significant difficulty or expense, unduly extensive, substantial, or disruptive, fundamentally altering the nature or operation of the business. All of this is on a case-by-case basis. It's going to depend upon the size of your company, how many employees you have, the finances that you have available, the type of job that they're in. Excuse me. There are certain jobs that, a reasonable accommodation just won't work. For example, if you have someone who wants a modified schedule, but in fact, they work on a crew with 20 other people, it will not be easy to change their schedule to be, instead of, they say, I can't work in the mornings because it's difficult for me to get started. I need to start at 10. Well, they work in a crew that starts at 8 and goes to 3. You can't necessarily change this particular individual's schedule to accommodate that one person. So again, but alternatively, you may have someone who works in an office and they work independently and they say, I need to start an hour later. That's probably okay. You can probably work with that. But again, it's going to be a case-by-case basis, determinative as to whether or not you can make the accommodation requested or offer some kind of alternative. Again, an employer has the discretion to choose among accommodations. Where requested accommodation presents an undue hardship, the employer can offer an alternative if one is available. That's where it gets tricky. And going to what Eric had brought up earlier with one of the questions, what happens if you don't have an accommodation? This would be the point that I would suggest that you engage counsel to discuss where you're at so you can figure out what your options are. But you really have to talk to this employee to see what other options are out there. Is this job not one that can actually work for this particular individual? Or is there some other kind of alternative that you can suggest that may be okay? Again, it's going to be imperative that you engage in that interactive dialogue. Keep the communication going, no matter how difficult it gets. And again, document the communication so that there's no miscommunication later and you guys are sure that you're on the same step. I thought this was interesting that I wanted to bring this to your attention. There's no specific amount of time that employers have to respond to an accommodation request, but they should respond as quickly as possible because unnecessary delays in responding or implementing an accommodation can result in a violation. So if an employee comes in and requests they need another ADA parking space in the parking lot, and you put it off, oh, well, we're not doing that now, we're not doing that now, we have a problem because now you haven't engaged in the communication. Maybe it's that, you talk to them and let them know, excuse me, that we'll need this much time before we can do that. Okay, but you need to keep the communication open and make sure that employees don't think that you're simply ignoring their request. I wanted to talk quickly about the ADA and COVID. I mean, certainly this is what's on everyone's mind right now, COVID, and certainly there are impacts with the ADA. First and foremost, please know that there is guidance from the government. The CDC and the EEOC has published useful information. Regularly check those sites for updates. They are continually updating their guidance, and in fact, the EEOC, when they publish new guidance, they actually put the dates as to when certain things are updated, so you can see what the most current is. And the CDC on its guidance is always dated as well. The CDC provides great information for dealing with COVID on a daily basis. So if you have issues that aren't necessarily ADA, but perhaps you have someone who is out sick, certainly this is relying on the CDC guidance is imperative to show employees that, look, we're doing what the government is telling us to do with respect to the CDC. This is what you need before you can return to work, or this is what you need if you were exposed. So that's helpful. The EEOC, in fact, has opined on certain ADA-related issues that I wanted to touch on. And I plopped these out of the internet and I put them right in because I wanted you to see the exact question because I think these are all very pertinent. So first, when an employer reopens the workplace and recalls employees, does the employer have to automatically grant telework as an accommodation? I got this question many, many times from clients. And in fact, the answer is no. If in fact you made teleworking an option from March to June, and then you shut it down and you wanted everyone back in the office, you do not automatically have to grant an extension for telework. That being said, you do have to engage in interactive dialogue to see if it's a reasonable accommodation that is necessary. To that end, if the employee says, I can't go in because of this, that, or the other thing, I can't be around people, perhaps you could visit whether or not there is a faraway office you could put them in. Everyone wearing masks, of course. Perhaps there is some other accommodation you can make, but certainly the ADA does not require you to eliminate an essential function as an accommodation for someone with a disability. So in this case, if you have an employee saying, I need to continue to work from home because of COVID and I can't be exposed, and that person perhaps works on a computer program or something that is only now in the office because everyone else in the team is brought back in the office, you don't need to eliminate that function or create a new position in order to allow that person to work from home, to continue to work from home. The employer has no obligation under the ADA to refrain from restoring all of an employee's essential duties at such time as it chooses to restore the prior work arrangement, and then evaluating any requests for continued or new accommodations. The next issue that I thought was pertinent today, if an employee has a pre-existing mental illness or disorder that has been exacerbated by COVID, may he now be entitled to a reasonable accommodation? Certainly, I think it's important to note that if you were hired at one point and there was no disability, that does not preclude you from any time in the future in coming up with some kind of disability or bringing to someone's attention that now you do have issues. So certainly this could be an issue that someone did not initially, maybe their mental illness was not, being flared up for any reason, but now with COVID, there is some kind of existing mental illness, anxiety, obsessive compulsive, post-traumatic stress. Again, with any accommodation, employers may ask questions to determine whether the condition is a disability. Again, you need a disability in order to engage in the reasonable accommodation interactive dialogue. And then discuss with the employee the need for the remote access. Is that the only option that's available? Again, it's going to require an interactive dialogue with the employee in order to determine whether or not there's some other option out there. Finally, I got this question a lot too from clients. Is an employee entitled to accommodation under the ADA in order to avoid exposing a family member who is at higher risk of severe illness from COVID? And in fact, the EEOC has said no. You do not have to accommodate an employee without a disability simply because they have someone at home with a disability. For example, an employee without a disability is not entitled under the ADA to telework as an accommodation simply because maybe their husband or their mother or their child or what have you has a disability. I think that that's an important one. And again, I got that question a lot from clients. So I'm going to move on to some hot topics. And these are some miscellaneous things that I wanted to just touch on today. Illegal drug use. Illegal drug use, current illegal drug use is not an ADA disability. However, someone who is recovering either from drug use or from alcoholism, that is considered disability. But again, active drug use or active drinking is not going to be covered under the ADA, but someone who's in recovery would be. Confidentiality. Whenever you're talking about these matters with your employees, make sure that you're keeping documentation, as I said before, but as we all probably know, medical information must be kept in a separate personnel file, not in the usual personnel file. Medical information should only be disclosed on a need-to-know basis. That being said, there are certainly situations where supervisors will need to know if an employee is disabled and what the reasonable accommodation is. I think when you have that discussion with your employees, with your manager or supervisor, letting them know, Sally came in today and she needs this, she needs to revise her work schedule, what have you, because of a disability. Share as much as you need, but don't share too much, and make sure that you tell that manager that this is confidential medical information you're sharing, but you must share it with them because they need to understand what the changes or accommodations are being made to that person's job. Okay, that was the substance of that was exactly an hour, good for us. Eric, are there any questions or should I move on to the case studies?
Yeah, we actually have 4 questions here. I'll just ask one and then, of course, wait for your response. So the first question, going back just a little bit, when working with job seekers, if they're apprehensive to ask for an accommodation, is there a time that you would recommend that they ask, whether it's during the interview or after they're hired, after they're working? Like, what would you feel the best time is for an employee to request a reasonable accommodation?
Well, I think that probably the best time that would come up would be going over the job description. I always suggest that during interviews, you actually go over the employee's job or the potential employee's job description with them so you can explain to them what those jobs are. And you may want to, at the end of that, say, any reason why you couldn't do any of these jobs, or this would be your job, how does it look? And I think that would be the perfect opportunity if there is a need for some kind of reasonable accommodation to afford the applicant an opportunity to say, hey, with respect to these hours, I can't do these hours, or with respect to this, I may need a a hearing accommodation or something like that. I think that would probably be best.
So the next question we have, with the topics you've covered today so far with reasonable accommodations, potential discrimination, how, if at all, would this apply in either a right to work or at-will employment state?
Okay, so right to work and at-will employment are terms that people love to throw around. Right to work actually has to do with unions, so it's not applicable at all. At will, Florida is an at-will state. And what does that mean? It means that employees and employers are both welcome to end the employment relationship at any time, with or without notice, with or without reason. For employers, it's important to note that it needs to be with or without reason, so long as it's not a reason pertaining to unlawful discrimination. So with respect to, can you fire someone if they come in to ask for a disability? Absolutely not. You have to engage in the interactive dialogue. You have to determine whether or not they can do the job with or without an accommodation. And then you have to engage in that discussion. Now, could there be instances where you must part ways with a particular individual because they have brought up accommodations that you just can't do? Yes, that's possible. But before you take that step, I would encourage you to seek the advice of your legal counsel. I would make sure that you have all your I's dotted and T's crossed, and I would make sure that you've explored every option out there that would afford this employee an opportunity to continue to work with or without that reasonable accommodation. Next.
Thank you. The next, and we have a few more questions here. The next question, how would any of this apply, or if at all, if the employee is working for either a staffing or a temp agency, or if they're a contractor under a 1099?
Okay, so if they're an independent contractor under 1099, the reasonable accommodation would not apply. That would be a contracting relationship. Certainly, I would still encourage the contractor to speak to the person that they're working under contract with, but the ADA would not necessarily apply to that relationship. With respect to the staffing agency, I think it would be imperative for the individual to talk to the staffing agency before they send them out for jobs, letting them know what, if any, restrictions they have. Once they are put in that job, I think it would be the same way. If there is some kind of need for a reasonable accommodation, they should go through HR and or whatever their relationship is with the staffing agency. I imagine staffing agencies have different rules. When there is an issue, that they either go to the staffing agency or they go to HR. But certainly, I think it would be incumbent upon the individual to make sure that their needs are outlined ahead of time, and then certainly can, the employer, it may not be that they can work for this particular employer, but maybe they can work for this particular employer. So I would hope that that would be a discussion they would have with their staffing agency before they even engage in accepting a position.
Thank you. And then I think this is the last question we have for now. Let's say there's an employee, hypothetically speaking, that is currently pregnant, and they have a doctor's note that they give their employer saying that we recommend that this employee, for the duration of the pregnancy, whatever the case may be, work from home due to an increased health risk. And then after that employee gives the employer the note, the employee says, oh, by the way, I can also work a few hours here and there in the office if you need me. So based upon that, would that employee need to get an amendment to the doctor's note stating that they could work partially at home and partially in the office if they've already submitted a note?
100%. Very good question. That happens a lot. You get a doctor's note from a doctor for an employee, that is gold. That is what you're going to follow. Certainly go over it with the employee and engage in the discussion. And if it turns out at that point in time that in fact the doctor says that you can't, as you said, they must work remotely, and the employee says, well, no, I can actually work in the office a couple of days. Okay, here's your doctor's note. Please take it back to your doctor and have them amend it, and we'd be happy to accommodate that. But no, most definitely, if you get a doctor's note saying this, it also falls in line with if you get a doctor's note from an individual that says, I can't work for another 4 weeks, and all of a sudden they call you up 2 weeks later and say, hey, I'm ready to come back to work. Great. Get an updated doctor's note and provide it, and we'd be happy to put you back to work. Your best defense would be we follow the doctor's orders. If you allow an employee to come back that's contrary to what the doctor says, that's going to be troubling moving forward, because 20 years ago, I wouldn't have said this, but I've been in this business for over 20 years now, and I can tell you that employees say what they want to say, hear what they want to hear. And if you're in a situation where you trusted a doctor's note and then the employee adjusted that doctor's note and you said, oh, well, the employee says this, if push comes to shove and you're involved in litigation, the employee might forget that they actually told you differently. So you want to make sure you get everything documented.
All right, thank you. That's all the questions we have for now.
Okay, perfect. I picked up 3 case studies that we'll talk about, and certainly if you guys have more questions, you're welcome to ask them. I'd be happy to answer them. So first, I'm going to read these. Employee was frequently absent from work due to alcoholism. The poor attendance continued even after the employee obtained treatment. Employee and employer entered into a last chance agreement where employee was placed on probation for a year. On a shift during the probationary period, employee appeared to be drunk, confronted the supervisor on duty, tipped over a desk, and attempted to throw a stool while being restrained by coworkers. He was fired. Employee sued employer claiming his actions were due to his alcoholism, which was a disability. Who should win? Let's digest this for a moment. So obviously, poor attendance is certainly a reason to separate someone. A last chance agreement, for those of you who don't know, is a great tool that employers can use if they're in a situation where an employee has done what's considered a terminable offense. They could be fired for this action. However, you want to give them another chance. So you put together a document called a last chance agreement, and the employee signs off on that. They recognize what they did was terminable. However, they're getting a second chance. So in this situation, they did that, and they in fact put the employee on a year probation in addition to any other things that they may have included in the last chance agreement. That being said, regardless of whether or not they were entered into a last chance agreement, the fact that they appeared for work drunk is going to be a terminable offense at this point in time. Again, as I mentioned earlier, alcoholism is a disability. However, it's not current use of alcohol, it's recovering alcoholism. And it certainly does not excuse the misconduct at work engaged in by an employee, even if the misconduct is caused by or related to the alcoholism. Therefore, the employer lawfully discharged the employee. Next, a crane operator, due to his disability, asked that his work schedule be changed. Rather than starting at 7, he wants to start at 8 and end work 1 hour later. The crane operator works with 3 other employees who cannot perform their jobs without the crane operator. As a result, if the employer adjusts his hours, it would have to require the other 2 workers to adjust their hours, find other work for them to do from 7 to 8, or have them do nothing. Is the employer required to grant the requested accommodation? I actually gave a similar example earlier on where it was a bigger crew. This is a small crew, but nevertheless, if you have a crew working, and in this case, the crane operator is required to work with the other 3 employees, otherwise you would have to have the other 3 employees change their entire shift. Now, could you do that? Sure. You could change the entire shift of everyone. Are you required to do that? Absolutely not. According to EEOC guidance, the employer would not be required to accommodate this employee because the proposed accommodation would cause an undue hardship. Having to change the schedules of 4 employees is not considered a reasonable accommodation. It would cause significant disruption in the employer's business because probably those 4 employees are tied to another shift or another job, and they're all intertwined, and these shifts were made in order to the best interest of the employer. Although the EEOC says the employer could deny the accommodation, it says the employer should discuss with the employee if there are other possible accommodations that would not result. Again, fact basis, case-by-case analysis, you need to communicate with the employee to determine, well, we can't do that. Here's what we can do, or what else could we do in order to figure out if there's another option. The third case study. Employee was employed as a teacher's aide. One of her duties was driving a van transporting children to and from school. Employee had a hearing impairment, which she had disclosed. School parent expressed concerns about whether the employee's hearing impairment placed the children at risk. Shortly thereafter, the school relieved her from her driving duties due to safety concerns. Were the school's actions lawful? They were not. The record contained evidence to allow the conclusion that the employee was able to drive the van safely, and it didn't pose a threat. She had a safe driving history and an unblemished history of supervising the children without incident. In fact, the school had evaluated her and had given her a driving score in excess of the minimum needed. As this case demonstrates, and I think this is a perfect way to end this discussion, employers need to perform an individualized assessment into whether a particular employee poses a direct threat. Same thing, they need to do an individualized assessment to see whether or not the reasonable accommodation that they're requested would work, whether or not there's another reasonable accommodation, what they can do to assist the employee. Decisions should not be based on suppositions or fears, rather they should be based on current medical knowledge. Again, keep in mind, we need those doctor's notes about the disability and the real risks that the disability may present, including how severe the harm may be. Again, it's essential that you get the doctor's notes. The doctor's notes are clear. Let me say to that too, Bari's rule, my rule is I never want employers to call doctors. Under the ADA, there is some language that would allow you to do that. I always chastise employers for doing that simply because, first and foremost, I don't want you getting more information than you need. Secondly, just as importantly, anything you get verbally from a doctor, you have no documentation to support what they said. Doctors have lots of patients. They may forget what they tell you. It is most important that if the employee's note is not clear, you hand it back to the employee and say, talk to your doctor and get clarification. Here's what we need. And again, if you recall, I mentioned earlier, sometimes I might send a little cover letter that talks about here's what they do. Specifically, they drive, they operate equipment. Please comment or please opine as to whether or not they can do this job. Get it in writing. Don't call the doctor. Don't listen to what the employee has to say verbally. Get it in writing. Eric, do we have any more questions and answers? Otherwise, I have one more thing I could touch on.
I just have, I guess, two more questions here that have come up. First question is, what, in addition to some of the things you talked about today, what other resources can you recommend for employers and employees to help them with the reasonable accommodation process?
There is, the DOL puts out the JAN network, which is the Job Accommodation Network, and it is a free service put on by the Department of Labor. The website is askjan.org. I would urge employers to go there. It does talk about different kind of accommodations and different things that employers can do. So that could be a first step, certainly. I encourage you to reach out to your labor and employment council to talk to them. They have the experience with these issues. And again, most importantly, talk to the employees, get their feedback, get their buy-in, and have the communications. It may not be that one discussion is going to answer all questions, but it may be a continuing effort until you actually get to the point where this is good, we can move forward from here, and we're good. And keep in mind that accommodations may need to change. Initially, employees may have certain restrictions and they may change over time. So if you do have a long-term employee that has a letter that says that they need this, that, or the other thing ongoing, feel free to tell them you need to update that every year or you need to update that every 6 months. It's a continuing, evolving type of discussion that you need to have with your employees. So I wanted to say one more thing. Because of what I do, and I deal with employers on a regular basis, most of my day is spent handling issues regarding leave or terminations or whatnot. So I've really been hearing from clients having to do with COVID, and I'm pivoting back to COVID because obviously it's on everyone's mind, especially with Thanksgiving next week. I will tell you, initially when all of this happened in March, I was getting inundated with calls about the new laws that came out and what do we do? And at that point, there weren't a lot of cases necessarily in our area, or at least that I was hearing about. Fast forward to end of June, beginning of July, a lot more cases were coming out, and it was very apparent that our area was being inundated because I was getting tons of calls from clients where their employees were sick. What do we do? How do we protect our other employees? I worked on a lot of policies to require masks in the workplace, to shut down your break room so the employees aren't sitting with each other, those types of things. I will tell you, in the recent week or so, I've gotten a lot of those calls. Again, it kind of died down after the end of June, beginning of July. Those calls are now coming a lot. So again, I know we all are getting fatigued and we keep hearing it on the TV, but I can tell you, for our area, for the employers that I deal with on a regular basis, the cases are becoming prevalent again. So I just want to encourage everyone to make smart decisions, talk to your employees about what they're doing on their downtime. Certainly we don't want to restrict their abilities to do things, but at the same time, we want to encourage them to make smart decisions, know who they are dealing with. And just as a side note, I've gotten a lot of calls from clients whose employees were doing everything right and they were limiting who they talked to. And on 2 separate occasions, employees may have said, well, we're going to go out to dinner with this one family, or we're going to see this one friend. And in fact, in both of those situations, those people actually had been exposed and were waiting for test results. So you may want to ask, before you see people, have you been exposed? Are you in fact waiting for a test results or going to get tested before you actually make the decision to go and see them? That was just my side note. And wear your masks. I think that's all I have, unless Eric, you have any other questions?
No, we don't have any other questions. Just a couple things before we wrap up. First of all, on behalf of CareerSource Palm Beach County, Disability Services, and our leadership team, we want to thank you and Ward and Damon for taking your time today to speak with us and share your expertise and knowledge. We definitely appreciate it. And if any other questions do come in, we'll let you know. I also want to share with our participants today that within the next day or so, we'll be emailing out the presentation materials along with the survey that we ask that you can complete and promptly send back to us. And again, we'll have that link. We hope you enjoyed today's topic. I know we certainly did here and got a lot of important and useful information out of it. We have some more coffee talks coming up in the series. December 9th, we'll be talking about anxiety and depression in the workplace. January 12th, we'll be exploring bipolar disorder in employment. And in February and March, we'll be looking into autism and developmental disabilities, and also possibly schizophrenia. And all that information we'll be sending out way in advance. We hope that you can register and join us for those events. I see one other question that actually just popped up. If we have time here in these last couple of minutes, how can employees, including HR professionals, deal with company leadership that may not adhere to local mandates regarding face covering? So that question just came up.
Well, I'm familiar with that. There are definitely leadership that are not wanting to be having face masks in the workplace. I will tell you that there's a Palm Beach County ordinance that requires it. So, you know, I guess it's the lawyer in me, but I always like to rely on the law. That's why with respect to, you know, when employees can come back and when you need to have them out, CDC guidance is very good on that, and I would rely on that. With respect to masks, it is clear in the Palm Beach County ordinance, which has been extended now 2 or 3 times and is currently valid, that workplaces, and trust me, I did an analysis on this, it covers all businesses, they must have masks in the workplace. So I do have at least one client that called me that said, and I can't remember which agency it was a local agency, was at their door saying, you don't have masks on, and they were threatening them with a significant fine. They gave them a warning, and they were going to come back the next day, and they needed to see the employees wearing face masks, otherwise there would be a fine. So it is real, it is out there. There are I know that the governor has kind of tied our hands, so that may not be happening anymore with respect to the agencies coming in to make sure that employers are compliant. But certainly, I think the whole idea behind being compliant with the Palm Beach County ordinance is it should be top of mind and should be what you show the leadership. Here's the law. It's a Palm Beach County ordinance. I don't know it off the top of my head, but if you go to the Palm Beach County government website in their executive orders, it is there, and it has been recently updated to extend throughout, I want to say, at least the month of November.
Thank you. I also, before we conclude today's session, just want to thank a couple additional individuals the Tennessee Captioning for providing the captions, and to Komen Certified Interpreting for providing our ASL interpreting services. They're both long-standing partners, and of course, we want to thank them for their support. And as well, Bari, thank you again for taking time out of your busy schedule. I know everything, especially like you said, in this, I don't think it's a new normal at this point, but in the norm as it is for now for the foreseeable future. We're sharing that with our guest today. And is there anything else you would like to share with our audience before we conclude today's session?
No, certainly if you have any questions, feel free to reach out to me. Also, you can find me on LinkedIn, and I try to post updates as to what's going on in the labor and employment field. You're welcome to add me, and I'm happy to do it. It was a pleasure. Thank you so much for having me. And everyone just stay safe. Happy Thanksgiving.
Likewise, happy Thanksgiving. Everyone out there, stay safe, stay healthy. We're glad you could join us here today. We hope to see you on December 9th. Again, that will be coming out soon, along with information, the presentation, and a survey. So thank you to all. Have a happy, healthy Thanksgiving, and we look forward to you joining us for our next session on December 9th. Stay well.
Bye.